parental rights has been an issue that we've been fighting a lot for. I mean, I'm not a parent, Nicole's not a parent, but I think this is primarily an issue of government overreach, and it's a common theme in states like Washington where they believe they know what's best for you. They believe they know what's best for your kids. They believe they can parent your kids better than you can. And we've seen what kind of parenting they do in our public school system. They're not focused on academic achievement, academic outcomes. They're not even focused on making sure that kids routinely show up to class. They're focused on identity politics, political indoctrination, social indoctrination, extreme gender ideology. And that is why there was so much support for Initiative 2081 last year. That's why around 500,000 Washingtonians signed that initiative to say, hey, we are the primary stakeholder in our children's lives. The school district, the public school district, which operates with our tax money, should not be hiding things from us as parents. My child should not be able to go to school, identify as a different name and gender, and you as a school keep that information from me. My child should not be able to go to school and get prescribed medications or be dealing with a mental health issue, and that information is kept private from me. That is what Initiative 2081 did, is it solidified a parental bill of rights. And to just put that stake in the ground and say, no, the government does not supersede my rights as a parent. The public school district does not have more rights to know what's going on in my child's life than I do. So you guys will know by now. I'm going to give a quick recap for those who might be new to the show or new to this issue. So Initiative 2081 is sent to the legislature. They felt like they had to pass it into law to avoid it going to the ballot, because if it went to the ballot, let's be honest, it was going to pass. So on a bipartisan basis, almost unanimously, Initiative 2081 became law. Almost immediately after it became law, what happened? The head of Washington's public school system, Chris Rakedall, said, I'm going to be the arbitrator of what's legal and not, and I don't think that aspects of this new law are legal. So no, Washington public schools will not be abiding by the Parental Bill of Rights. Yes, we will continue to hide medical information from parents. And he made this claim, again, as if he's the arbitrator of constitutionality. He made this claim that, okay, this is in violation of federal privacy rights for students, so we're going to continue to keep this critical health information from parents. And then there were lawsuits, of course, lawsuits that sought to get the entire Parental Bill of Rights thrown out. So that's sort of where we're at. I am happy to report that one of those lawsuits has now been thrown out. This ruling came down. There's a lot of fascinating aspects of this, but one of the most fascinating things is it was a King County judge that said that the challenge to Initiative 2081 and the Parental Bill of Rights law has no merit. So this came out, Judge Michael Scott, as Nicole noted, Michael Scott of The Office has found a new career as a King County Superior Court judge. The court concludes that there are no genuine issues of material fact in dispute as to the constitutionality of Initiative 2081, and concludes that the plaintiff's motion for summary judgment is denied in its entirety. This lawsuit was brought about by the Legal Counsel for Youth and Children versus the state of Washington and, of course, Let's Go Washington, the entity that ran the initiative. So a few things here. The state of Washington, with the help of outside counsel, has successfully defended Initiative 2081 in the first real test. I think this is a good thing. I think they're worthy of praise. Of course, if there's a law on the books, something passed by the legislature, an initiative, it falls to the Attorney General's office to defend the will of voters in a court of law. That was concerning to me. I was very concerned about these legal challenges. I questioned the incoming Attorney General, Nick Brown, about them. Because not only was he not in favor of the initiatives, neither was Bob Ferguson, who's now our governor. So I had asked Nick Brown at the time, this was actually before the election, can we trust you to defend what will be legal challenges against the initiatives, considering you personally don't support them? And he said, absolutely. I will support them, and my office will defend them to the best of our ability, if and when they become law. And so this is an example of, okay, they were able to do that, but not without some outside help. So because there was so little trust that the state of Washington and Democratic politicians would defend the Parental Bill of Rights, our old friend Pete Serrano, who is with the Silent Majority Foundation, also had run unsuccessfully for Attorney General, they asked to be joined with the state of Washington in the defense of Initiative 2081. So they were, in this case, they sat side by side with the lawyers from the state of Washington to get this outcome. Now, I'm going to get into Pete. Pete is joining us in a moment. What happens from here, but this is a big win, and I just want to be clear about that. The Office of Superintendent of Public Instruction, Superintendent Kruse, who had said, oh, we're not implementing all of this. I think some of it is unconstitutional. This King County judge is saying, no, it's not. You have to implement the Parental Bill of Rights in its entirety. No, you cannot just decide to continue to keep information from parents. So as of today, the Parental Bill of Rights should be in full effect in every public school district in the state because of this ruling. As I mentioned, Pete Serrano and his team at the Silent Majority Foundation joined the Attorney General's office in its defense of the Parental Bill of Rights. Pete Serrano joins us now. Pete Serrano, welcome back to Undivided.
Brandi, thanks for having me back.
Yeah, so you actually, Silent Majority Foundation is defending the Parental Bill of Rights side by side with the Attorney General's office, correct?
Yeah, it's ironic. 2 weeks ago, Friday the 14th, I was in court against the same attorneys who we sat side by side defending last Friday this Parents' Bill of Rights in King County. I guess the distinction was we were at the Supreme Court in Thurston, and we had to switch benches or something to get to King County. But yeah, it's a wild world where we're at least paired up, we'll call it that.
Yeah, I mean, obviously the result is what we want it to be, but would you say that the Attorney General's office has been putting their full faith and effort into defending the Parental Rights Initiative?
I will say they have, and I want to give them credit where credit's due, because I think so everyone, just we'll do a quick time capsule. The Parents' Bill of Rights was an initiative. It passes through the initiative process, goes to the legislature, gets adopted as legislation last May, and then a bunch of the left groups, LCYC, which is all about children's rights and youth, protecting them, challenge this Parents' Bill of Rights, saying, no, you can't have 10-day access to our records. No, you can't have access to our mental and physiological treatments that are occurring on campus, right?
Yeah.
Because God forbid a parent knows what happens behind closed doors at a school. And so they make this challenge, and it's in King County Superior Court. Our concern as an organization, and I think generally the people who supported the bill were wondering, is Bob Ferguson, then Attorney General, going to put full faith and credit into defending this?
Because he didn't support the initiative, and neither did Nick Brown.
Yeah, he was very clear that he did not support it, and obviously Chris Reichdahl's gone off a handful of times about the impact of these limited youth. And so we sought we're granted what's called intervention status on behalf of Project 42, Jim Walsh, Informed Choice of Washington, One Washington, meaning these groups wanted us to co-defend 2081 and its subsequent law with the state of Washington, again, because we weren't sure, based on those very public statements. I think it was a press release and an op-ed or some sort of video that Bob Ferguson did saying he wasn't in support of it. And so, I will give the state again credit where it's due. They did a wonderful job, articulating why this bill was constitutional and why it doesn't violate or void other parts of the law. Unlike any other legislation where, you can modify the law. And it's like some of the arguments from the other groups were crazy. It was, well, the legislature didn't know what they were doing. And it's like, fast forward to 2025, we know they darn well knew what they were doing. Yeah. And that's a whole nother story for this.
Yeah. And I just want to clarify, you keep saying Project 42. I think you mean Let's Go Washington, right?
Yeah, I apologize.
No,
yes,
okay.
Well, Let's Go Washington.
Yeah.
That's my bad.
So the challenge, and we'll get to what they're trying to do with it now, but Chris Reichdahl had said, oh, this violates children's privacy rights and the federal law, and he had sent out a thing right after the Parental Bill of Rights went into effect that they just weren't going to follow aspects of it. Like that he was the arbiter basically of whether it was legal and constitutional. So what happens now? The court has denied that claim. I want to read really quickly. We just read it before we came on for the segment, but it says, having considered all papers filed in support and in opposition, the court concludes that there are no genuine issues of material fact in dispute as to the constitutionality of Initiative 2081. So what does that mean today for the public school system and its implementation of the Parental Bill of Rights?
So what it means as of yesterday, when this order was signed by Judge Scott and entered into the docket, that the Parents' Bill of Rights, as written in 2024, is 100% intact. So it's intact. Nothing is touched. If you recall, there was a temporary injunction stating, oh, the 10-day and a couple of mental health things, we're going to put a pause on implementation of those. But the entire bill, based on this ruling from Judge Scott in King County last week, based on this order, the case is entirely dismissed and the entire bill is back in action.
So that means that OSPI and what Kruse Reichdahl said about, oh, we're not going to, implement some of these medical, things for parents to know, that is done.
Yeah, absolutely. So, if Kruse Reichdahl or your local school district were to say, oh, well, we don't have to follow this because of the injunction or for any other reason, because I'm Kruse Reichdahl and I say so, seems to be his mantra. There would be, quite frankly, in my opinion, ample fodder for a lawsuit to recall the individual, because then they are, in fact, violating the law, which is currently entirely intact.
Yeah. Now, that is obviously all separate from the effort happening in Olympia right now to amend Initiative 2081 in the Parental Bill of Rights. There are two bills, matching bills, one going through the House, one going through the Senate, where they want to basically take a lot of the key provisions out when it comes to notifying parents of medical issues their kids are having, gender dysphoria, mental health issues, etc. So that would be a different fight for a different day, right?
Absolutely. And that's why I'm grateful I have the opportunity to talk about this today with you. What the viewers need to know is, yeah, right now, things are great. We've preserved it. The state's preserved the law. You have all of the authorities in the district has all obligations falling under 2081. However, and this is like all caps and bold, however, those two bills, I think it's 1286 in the House and 5181 in the Senate, are looking to gut these provisions, and we need to be ready to act swiftly. I talked with a couple of other media outlets, and I suggested, hey, someone organize a rally. I'd love to do it, Silent Majority Foundation, but we gotta, I'm in a suit because I just came from court. We've got stuff that we've got to handle, but if someone wants to organize a rally, and this is not a 200 to 300 person rally, tens of thousands or more walking on the Capitol, holding the signs, I'm a parent, I want my rights protected. We have to engage this session on a myriad of bills, but these two bills in particular. If you're a parent, grandparent, parent adjacent, I guess is what we'll call it, go have your voice be heard over the next 5 months.
Amen. All right, Pete Serrano, still fighting the good fight out there. Congratulations on this ruling. I'm glad you and the Attorney General's office were able to work together on this one, and thank you for giving them credit where credit is due, because Nick Brown promised us that he would defend all of this with all the might of the office, and so far so good. So thank you, sir.
Thank you very much. Appreciate you having me.
I'm gonna steal his phrase, parent adjacent, because we're parent adjacent. I think everyone's parent adjacent, because I want parents to have say over what's happening with their kids. That's a really reasonable thing. It's not a controversial opinion, and it's sick and twisted that after all of that effort, Parental Rights Initiative, signed into law, surviving lawsuits, totally constitutional as we speak today, Democrats in Olympia are trying to water down that bill, water down that law. The two, they're matching bills. The House version that attacks the parental rights law is 1296. The Senate version is 5181. You can today, right now, email your elected representatives, your elected senator in Olympia, and you can tell them that you are not in favor of House Bill 1296 and Senate Bill 5181. That as a parent, courts have now said that it's totally constitutional for you to expect that medical information related to your child at school is not going to be hidden from you. House Bill 1296, Senate Bill 5181. So we won a battle, but the war still rages on to protect parental rights, and we will be with you fighting every step of the way.